Hello, everyone. The new year, we are presented with 3 new criminal law bills, which seek to replace the Indian Penal Code, the Indian Evidence Act, as well as the Code of Criminal Procedure. So these new laws are the Bharatiya Nyaya Sanhita, which seeks to replace the IPC, the Bharatiya Nagarik Suraksha Sanhita, which seeks to replace the CRPC, and the Bharatiya Sakshi Adhiniyam, the replacement of the Indian Evidence Act. So these laws, although they have received the assent of the president, they are yet to come into force. They'll come into force as soon as the government notifies the date of commencement. So these laws are completely changing the criminal law or criminal justice system. There are a lot of changes. So to discuss the impact of these changes, we have with us Professor Anup Surendranath of National Law University, Delhi. Welcome, Anup. Thank you for joining our show.
Yeah, thanks, Manu. Thanks for having me.
So the first question which I have to you is that a major message which the government has been emphasizing while introducing these bills is that of decolonization. So the government has said that these bills will decolonize the criminal law system and will destroy or dismantle the colonial legacy of our criminal justice system. So how do you think these laws will signify a departure from the colonial legacy of our criminal laws?
Yeah, I mean, it's an interesting argument, Manu, but I'm not sure what it means really. It rings as a hollow argument because what makes it colonial, right? And in asking that question, is it the fact that they were first drafted and brought into force during the colonial era that makes it colonial? I mean, in that sense, what about the IPC would you say is colonial? And I think it's a very shallow argument to say that, you know, what we really mean by colonial is that it was enacted during that time, but rather what we really need to focus on is when we say that something is a colonial law or a colonial institution, is the relationship between the state and the citizen, right? And that a colonial state had a certain logic of control and power, and using criminal law to control in that sense, the native population. And that is the relationship and the use that the colonial government had for criminal law. And I don't think that dynamic has changed with these new laws that have been passed by Parliament. The nature of and the use of criminal law continues to be to control the population, right? To expand the scope of operation, very vague provisions, much wider police powers, and we are not reforming our criminal justice institutions. The criminal justice institutions remain the same and they will continue to function in the same way. And in that sense, nothing much has changed. The colonial logic continues. We have reused and repurposed the colonial logic even in these new laws. Therefore, the argument of decolonization rings rather hollow according to me.
So you're saying that except for the change in the name, the substantive provisions more or less remain the same?
Yes, the label has changed, but the nature of the use of criminal law by the state continues to be the same. And the criminal justice institutions that will then enforce these criminal laws continues to be the same. And there is no fundamental shift in that relationship between the state and the citizen through criminal law. And therefore, the colonial logic continues as much as any other time in India's independent history. These criminal laws and the criminal justice institutions continue to be a legacy of that colonial logic.
So according to you, these bills do not reform the criminal law system as such. There is no reform.
Absolutely not. I think reform would be a very, very wrong word to use. As far as these laws are concerned. It was a tremendous opportunity to reform India's criminal justice system, but there is no reform being delivered here through these laws.
So do you think that there are any positive changes which these laws have brought in?
Of course. I mean, there are positive changes and there is the potential for change, but none of that is in the nature of overhauling or reform or decolonization. Are there changes? Yes, there are changes. Are some of those changes potentially good? Yes, and I'm deliberately using the word potentially because a lot will be required to be done for those good changes to take effect. And some of those are like the audiovisual recording for all search and seizure procedures. That is certainly a good development. The need for forensic experts to be present at crime scenes where offenses punishable with more than 7 years are involved, that is a positive development. There are timelines for different stages of the criminal justice process, and particularly the one about 45 days within which a judgment has to be given after judgment is reserved. That is of great importance, I would think. The provision on deemed sanction is another improvement, that for deemed sanction for prosecuting public officials, if it's not given within 120 days, it's deemed sanction. Victim participation. Look, all of these are potentially very good changes. But is there institutional capacity? I don't think so. And I don't think anybody would contest that. Anybody who's reasonably familiar with the realities of India's criminal justice system would not contest the point that we are nowhere near being able to implement these changes. And apart from the ability and the capacity of institutions to bring about these changes, even in things like audiovisual recordings, there are some things that are not entirely very clear as to how they will play out in terms of how are we going to make regulations around the digital infrastructure required to record these things? Where will it be stored? What are the instruments that we will be used to record it? Who will have access to this? Will all accused persons be given access to this? What are the consequences if you do not record these search and seizure procedures? So and similarly on forensic experts, yes, the law says that in a certain time from now, all crime scenes where the offenses are punishable with more than 7 years should have a forensic expert on the scene. How are we going to do this if you look at the state of our forensics infrastructure, right? So while, yes, there are some of these changes that are potentially good, it is very scant on detail as to where is the institutional capacity going to come from. While there are changes in the laws, it isn't met with a corresponding change in the capacity of institutions. And I'm saying this even for the good things in these laws, or the good changes, or potentially good changes, like the timelines. A lot has been spoken about how timelines are being provided for. But how are we going to ensure these timelines without the institutional capacity? And another thing that I want to say is that everything seems to, particularly this provision of what is the replacement to the current 436A, where now they have now said that if you've served 1/3 of your sentence, you can be released. But they have now said that you are disqualified from taking benefit of this if you are being prosecuted for a life imprisonment offense or a death sentence offense. In the current 436A, the disqualification on life imprisonment is not there. So while you have reduced it from half to 1/3 with the new laws, you have increased the scope of the disqualification and said that if you're being prosecuted for a life imprisonment offense, you cannot take benefit of this. So yes, we've gone from half to 1/3, but the scope of the disqualification has been enlarged. So, so even these potentially good changes come with a lot of ifs and buts, and only time will tell us how they will play out, really.
Yes. So in other words, you are saying that without corresponding infrastructural reforms and police reforms and judicial reforms, these changes would only remain in paper.
Yeah, without police reforms, without judicial reforms, and without prison reforms, all of this is, it looks good on paper, potentially good on paper, but whether they will actually mean anything on the ground really remains to be seen.
So do you think that even these changes necessitated a complete overhaul of the criminal law system, or these could have been achieved through amendments to the existing laws?
I assume what you mean by overhaul is that now we are planning, or whatever the government is suggesting, that it will repeal the IPC, the CRPC, and the Indian Evidence Act and replace it with these laws. In substance, more or less about 80 to 85% of the provisions are the same, right? So in that sense, substantively, there is no overhaul, but administratively, they seem to be setting themselves up for an overhaul. And that is very, very challenging. And I don't think we are talking enough about that, of what is this administrative overhaul going to look like? Even these provision numbers are changing, and suddenly murder is not section 300, it is something else in the BNS, right? Or bail provisions are changing. Just imagine the administrative ramifications of all of this. And the question that you asked, even if you wanted to bring in the kind of changes that these laws have been, does it require a complete repeal and suddenly changing all the numbers, but 85% of the text is remaining the same and causing this potential administrative havoc? Is certainly not worth it. All that you needed were some amendments. Even if these potentially good things had to be brought in, they could have very well done with amendments to the existing laws. And look, Manu, one point needs to be made clear, right? India is not the only country in the world that had Macaulay's IPC, right? Or Fitzjames-Stevens Indian Evidence Act, right? Across Africa, across Southeast Asia, across South Asia, there are countries that had the IPC. They continue to have the Macaulay's Penal Code, because there is a certain cost and havoc that will be created by tampering with this administratively, right? And that goes back to the first question that you asked. What is so colonial about the contents of the IPC that you can't remedy it by amendments? And I think that is the critical question to answer. Now you are now setting yourself, imagine the amount of changes and training and orientations that the police and the prisons and the court systems will have to undergo to bring into effect these changes, right? And just namesake changes, because the really meaningful substantive changes could have been done through amendments. But now you have taken this risk, massive risk, of this administrative overhaul that is going to be required by changing these names and numbers of these provisions. So, I don't know how the government and the central government and the state governments plan to roll this out, but I would think it is administratively a huge risk that's being taken for very little gain substantively.
So this BNS, the replacement of the IPC, has omitted the offense of sedition. And however, there is a corresponding provision which penalizes acts which endanger the sovereignty and integrity of India. So Home Minister Amit Shah, during the Lok Sabha discussion, he said that sedition penalized acts which are against the government, whereas the new provision that penalizes acts which endanger the country. So he said that there was a criticism that sedition was being used to stifle criticism against the government and was being applied against people who voice dissent. So he said that the new provision will ensure that the critical voices of the government, they won't be prosecuted. Only the acts which endanger the integrity of the country and instead of the government will be targeted or will be prosecuted. So he said that this will ensure that critics of the government won't face any prosecution, and only people who act against the nation, they will face the prosecution or the criminal action. So how do you think this provision will play out?
At the end of the day, it is that police officer on the ground from the Thana who is going to come and first decide, whether what you have done is against endangering the unity and integrity of their country. And if you look at the new provision, the kind of actions that could potentially be brought under it, they are so vaguely worded, right, that it gives a very wide and expansive powers to the police, right? And as with sedition, and as with all such vaguely worded provisions, we will see that the process is the punishment, right? And convictions are going to be very, very low, because you've so vague, the words that you have used and I would urge everyone listening to this to go and read section 152 of the BNS to see the potential for misuse and how vaguely it's worded and how so many things can come under it, right? Yes, ultimately, when a judge applies his or her mind to it, the case might not be made out, and that is even shown in the sedition cases, how the conviction rates are so low, right? Or even barely cases are going up until that stage. And the same is going to happen. You have now created a very vague provision. You have created this idea of against the interests of the country and unity and integrity of the country and the sovereignty of the country. But there is no guidance to that police officer when and where to exercise his or her police powers, right? And therefore, for the common citizen, this must be very worrying. It has only widened police powers and not really restricted it or streamlined it in any way. Will there be convictions under this for that kind of exercise of police powers? I think it will suffer the same fate as sedition. We will not see cases going up until going into trial and getting convictions. The same thing is going to happen. But we are going to use this provision to arrest people and put them in prison and keep them there for a while they battle the criminal justice system, right? And that's what's going to happen. And in that sense, Section 152 only further enhances and broadens police powers, and that should worry all of us.
So the BNS also has incorporated the offense of terrorism, and the definition is exactly the same as the definition used in UAPA. So basically, the UAPA offense has been added in the BNS as well. So you have two statutes which are dealing with the same offense and which can be parallelly applied. So how do you think, so does this incorporation of this offense of terrorism, which is also quite widely worded, raise any apprehensions of misuse?
Yeah, look, this is something that really defies logic, right? And I assume most of the listeners here today are going to be people connected with the law in some way or the other, right? And I think this is going to require what? Now, in the second version of the bills, they corrected it. And the first version of the bills had a very different definition. Anyway, responding to various reactions, the definition has been made the same as the UAPA. There is a proviso to 113 of, there's an explanation, I think there's an explanation to 113 of the BNS saying that an officer not below the rank of the SP will decide whether to register the case under UAPA or under the BNS. Now, I would ask everyone listening to this and also you, Manu, does that mean that you can no longer file under both? And you can no longer register the case under BNS and UAPA whenever it comes into force? Will you have to necessarily choose only one to register the case? And anyway, that does not mean that even if the police officer registers the case only under one, that a judge cannot then add the additional charge under the other. Now, if you have for the same act, you have two different provisions, and those laws have very different procedures attached to them, right? For example, under the UAPA, the IO has to be of a certain rank or higher than that, right? The investigating officer under the UAPA has to be of a certain rank or higher. Now, that need not be the case under the BNS because there is no corresponding provision in the BNSS on this, right? Similarly, what happens to the bail provision under the UAPA, right? For 43D5, then are you saying that you can get bail under the BNS? Now, look, there is I think there's a fundamental legal problem here, right? It is very different if for the same set of actions, or let's say for the same act, they constitute two different offenses, A and B, right? The act might be the same, but that act might satisfy the elements of two different offenses, A and B. That might be a justifiable solution to a justifiable proposition under which there might be different procedures, right? But here, the same act is leading to the same two offenses. The constituent elements of the offenses are exactly the same, but you have two different procedures, right? You have two different procedural elements for the same set of actions that then go on to satisfy the same elements of the offenses. There is no difference in the elements of the offenses. It's the same offense, right? But just on the decision of an SP, I can be governed either by the procedure under the BNSS or I can be governed under the procedure of the UAPA. Now, that seems the classic definition of arbitrariness, right? Now, and for me, that this is going to have to be resolved if at all the government is going to bring this into force. This is one of the things that immediately the Supreme Court will have to clarify, right? Otherwise, it is just a very, very dangerous situation where you now have what was meant to be a special law now is being made part of of the ordinary criminal law, right? And without, I mean, for whatever it's worth, not that the provision in the UAPA that the investigating officer will be of a certain rank or above has led to any meaningful protection, but even that is being taken away, right? By bringing it under the BNS, even that, not again, just at the risk of repetition, not that that was any great protection, but even that is being taken away by bringing it under the BNS and making it part of general criminal law, right? So, you know, I think a really confusing and ill-advised move from the government on this, and I don't think it's been thought through properly from just the perspective of criminal law and procedure.
Okay. So the BNSS has a provision which enables the police to seek custody beyond the first 15 days of arrest. So this is a fundamental departure from the present CRPC. And even the parliamentary committee also raised some concerns regarding this procedure and said that there should be certain strict guidelines as to when this provision can be applied. Even the committee had pointed out that there is certain drafting ambiguity in the provision, although the intent seems to be that the total cap should be 15 days. The higher cap of the police custody should be 15 days. But the drafting seems to be suggesting that even that can be exceeded. So even the committee had pointed out that there should be some clarity in that. But the BNS has retained the same provision. So how do you, what is your perception regarding this?
Yes, I think everybody, every lawyer and every citizen of this country must read 187 of the BNSS and compare it to 167 subsection 2A proviso and see the danger that lurks in 187 BNSS. It is the reading of 187 BNSS it is entirely what it is suggesting and what it is saying, irrespective of what the intention is. We cannot now, as far as criminal procedure and criminal law is, we cannot go by what the intention articulated in Parliament is. It is what do the words of the provision allow. And the words of the provision, 187 BNSS, clearly allows police custody up to 60 or 90 days, depending on what offense you're talking about. There is no escaping that, right? Yes, the intention might be to say up to 15 days of maximum police custody, but you can take those 15 days anywhere between 60 or 90 days. That might be the intention. But it's mind-boggling that that's not how criminal law and procedure works. I cannot, when I'm being some prosecutor somewhere or some IO somewhere is going to use this provision to extend police custody beyond 15 days. We cannot go by what the government's intention while drafting it is. We have to go by the language, and the language there, I urge anybody to just read that language and see. a police custody up to 60 or 90 days is entirely permissible as the provision stands under 187 BNSS as of now. And I don't know. I really hope better sense will prevail and the statutory language of 187 BNSS will be altered to be in tune with 167 CRPC.
So, and I think that on a practical level, this will also make securing of bail difficult, because in most cases, what happens is once a bail application is filed, after the police custody period is over, after the 15 days period is over, they're just to grant bail. But now the prosecutor can say, okay, they might require police custody after 15 days also. So
absolutely.
I think that could be a practical fallout also.
Absolutely.
Okay. So, Anup, you as leading the Project 39, you have been dealing with a lot of death penalty cases. So now the BNS has retained death penalty. But do you think that the statute could have made certain, certain clarity by incorporating certain guidelines laid down by the Supreme Court regarding the exercise of discretion in awarding death penalty? Because the Supreme Court has laid down a lot of guidelines. So do you think that the BNS ought to have incorporated these guidelines to give more clarity as to when death penalty can be awarded?
Yeah. So just before I get to that, a couple of quick points, Manu. I think it was very instructive that even the Parliamentary Standing Committee did not provide a ringing endorsement of the death penalty and instead stated that there have been causes for concern and they leave the question to the government, right? I mean, one could imagine very well that they could have said that, yes, death penalty is a great thing and we must have it. And that is not what they said. So, to whatever extent, the needle has moved a little even for the Parliamentary Standing Committee to leave it open to the government. But it is unfortunate that the government continued with its enthusiasm for the death penalty. Not only has the death penalty been retained, that the applicability of the death penalty has been expanded in the BNS, including for gang rape gang rape against children below the age of 18, making it more consistent with the POCSO provision, mob lynching, and also for organized crime and terrorist offenses if it results in death. So there is an actual expansion of the death penalty and not just retaining the death penalty. But it's quite surprising that many of the concerns that the Supreme Court has addressed as far as fairness in the sentencing procedure is concerned is not reflected in the BNSS, right? I think Supreme Court judgments, Law Commission reports have repeatedly highlighted the concern with the arbitrariness in the procedure that is followed to determine whether an individual must be sentenced to death or not. And given that we're talking of actual lives of people, one would have expected that those procedural protections that the court has developed would find legislative articulation in the BNSS. But unfortunately, that's not what we are seeing. Instead, we see an expansion of death-eligible offences with very little guidance on the procedure that judges must follow before imposing the death sentence. I thought it was a great opportunity for more broadly sentencing reforms per se, not just death penalty sentencing, but we don't see any movement in these new laws on sentencing reforms at all. Rather unfortunate and certainly an opportunity missed there.
So the new laws have also introduced certain restrictions regarding mercy petitions as well. So there is a timeline given for filing mercy petition, and if it is not filed within that timeline, the convict forfeits that right. And also there is a restriction that third parties or NGOs are barred from filing mercy petitions on behalf of death convicts. So the justification given by the Home Minister in the Lok Sabha was that if that convict is not feeling any remorse, and if he himself or he or she herself is not filing the mercy petition, then a third party should not be allowed to file the mercy petition. So how do you think, what is your perception regarding this?
I mean, these are provisions, Manu, I think, that are completely divorced from the reality of our criminal justice system. Who is on death row in India? No rich person is on death row in India. No well-informed, well-educated person who knows their rights and everything is on death row in India. The reason why people don't file appeals or don't file mercy petitions on time are because there is no one to advise them. They are unaware, right? Or even if, and you should see even the mercy petitions that some of the prisons send are so pro forma, they're so meaningless, right? So when you know that this is the reality of India's criminal justice system and the death penalty in India, that it is our poorest, are from the most marginalized section, these are the people on death row. A provision like this is just unfathomable. What I mean, it is the final opportunity for a death row convict to have the president or the governor consider their plea for clemency, which are not then bound by the constraints of the court of law. The governor or the president are not bound by the constraints of the court of law and can consider a much wider set of circumstances and considerations. And given who's on India's death row, this really is an unfair and discriminatory provision against the poor. And it is not certainly and when a person is deciding even not to exercise their option for clemency, it needs to be explained very clearly to them what this means, what will happen to them, and how are we going to ensure all of that. We can't just automatically assume that that person sitting on death row for so many years suddenly is aware of all this information and is well informed and is taking an informed decision. How are we going to ensure that, right? And ultimately, it's a life at stake. Every life needs to be valued in the sense that every constitutional opportunity and every constitutional avenue should be allowed to be explored, right? And that even if the death sentence is to be there, it has to be enforced as per the law of the land, right? And taking away or constricting this opportunity for consideration of clemency just seems very, very unjustified and completely out of sync with the reality of death row in India.
Okay. So do you think any of the provisions of the new laws are so unconstitutional or so patently arbitrary that they are liable to be struck down by the courts?
Yeah, I think the police custody issue will be litigated very, very soon. And I think, unfortunately, our criminal law jurisprudence and our constitutional law jurisprudence is going to struggle to find the vocabulary and the language through which that will be articulated, right? What is so wrong about a provision allowing for 60 days of police custody or 90 days of police custody? What is so wrong about it? And how will the manner in which we will articulate that, right, is going to be not just important in this context, but in a much wider context of what is happening to criminal law in this country, right? And I think that provision of the BNSS, that is 187 of the BNSS, is patently unconstitutional. Another issue that is going to come up, and I think has been, and it's high time that we confront this issue in our criminal law jurisprudence, is the vagueness of these provisions. When does vagueness breach a certain constitutional threshold? Now, if you look at the section 152, which replaces the sedition provision, or section 197 1D on misinformation, the absolute lack of clarity as to what conduct is being criminalized, this cannot meet the constitutional threshold that a criminal law needs to be clear. It needs to be abundantly clear. And it was one of the guiding principles when Macaulay drafted the IPC, is of clarity. It should be very clear to the public and to the citizen as to what conduct exactly is being criminalized. Now, if you read these provisions, you will not make out as to what conduct is being criminalized. And vagueness as a constitutional problem with that criminal law suffers from, and these provisions will have to be tested. And unfortunately, we haven't done too well on this intersection of vagueness as a problem with certain criminal law provisions and how that interacts with constitutional law and constitutional thresholds. So I would think that that is another issue. Handcuffing, I think, has been discussed quite a bit. But I think one other thing that we will have to look at is Section 84 of the BNSS on a proclaimed offender, read with Section 356 of the BNSS on trial in absentia, right? That a proclaimed offender under Section 84, under certain circumstances, a trial can proceed in absentia under Section 356 of the BNSS. I mean, again, is pushing those constitutional limits. Whether it is pushing it to an acceptable limit or not, I think we will have to see. And I think when we decide the constitutionality, or if this does get litigated, the constitutionality of this trial in absentia provision, we need to be clear that, or we just need to avoid the trap of thinking that this is somehow only about the Nirav Modis and the Malyas of this world, right? That the provisions could apply much more broadly to a much wider, and we need to keep the reality of our country in mind, of who is trapped in our criminal justice system, against whom is criminal law most applied, and it is against the poor and the marginalized, right? And who is in our prisons? It's the poor and the marginalized that are in our prisons, right? And therefore, when we look at the constitutionality, or if at all we come to visit the constitutionality of Section 84 on proclaimed offender and 356 on trial in absentia, I think we would be well advised to think of its very wide amplitude of application in terms of who it can be made applicable to, and not just think of certain specific examples and then say, yes, for these kind of people, we need these kind of provisions, because it's not just applicable to those kind of people.
So Anu, before concluding, your concluding thoughts, or you can just summarize in 2 or 3 sentences about what you feel about this criminal law.
Right. I think I'm left with a sense of a tremendous opportunity for truly transforming our criminal justice system has been missed. That opportunity has been missed. There is no transformation in these new laws. It is certainly a continuation of the colonial logic, where the state wants as much power to control the people that it is ruling over, right? And that colonial logic continues in these laws with wider and wider state powers.
So thank you so much, Anup, for spending your time. Thank you so much.
Thank you, Manu. Thanks for having me. Bye.